ladies and gentlemen, gentlemen and ladies, ladies and gents. This young man, low key, from the UK, is singing a song that's gonna be my anthem. I'm back. So go ahead and let him know, Low. Thought he wasn't gonna say it, didn't you? No, I just need to know, did you guys forget about me? Because I was trying very hard to forget about y'all. But, as he's saying, I'm back. And no, I haven't learned my lesson. I'm about to make sure that I let everybody know why I'm back, the reason I'm here, and give them an understanding. Alright? We're gonna let Low Key play in the background while I try to do some educating of my kinsfolks. Alright, y'all with me? Alright, hey Low, we're gonna bring you down about 2 digits to number 2. Nah, we'll put you at number 3. Uh, I want to be able to hear the young man, but I don't want him to outdo me. So we're going to be playing some Luther, some Mariah's, some R. Kelly, some Nayo, some Mister, some Rolls Royce, some Robert Bookins, and some Stephanie Mills, some Ray Charles, and some Rashawn Patterson. Just so that you all know. Now, look, I got this folder right here. It's the I'm Back folder. That's right. The folder is specially for you guys. Now, there's a gentleman out there. He runs a website called I Am Some Dude. Okay? Mr. I Am Some Dude is a part of the Redress Update contact group, and he and I have been in contact in the past. But let me let you know a little something about Mr. I Am Some Dude. I believe he's at IamSomeDude.com. But ladies and gentlemen, let me see if I can go to I Am Some Dude. This is his website, IamSomeDude.com. Can you see it? Because I'm not going to make it any brighter or bigger than what it is. Alright, let's get back off of the I Am Some Dude, and we got to go to Modified Documents. Because we're looking for... Wait, I'm looking for dates. Oh, okay, I see what it is. Those are the folders all the way down there. We got to go all the way up here. We're going to look at something. Now, I want to look at that. And I can't look at that because that's just... Oh, that's right, I converted it. Let's see if it worked. Because there's some information here all of you need to know. And then we're going to get into some conversations about what's been going on. And we're going to educate you guys on the current status of law. Now, it didn't turn out the way I wanted it, but it did what it needed to do. This is from a book called Corpus Juris Secundum. Sorry, I haven't loaded this up yet. Oh, man, if you guys can hear that, that's the Commodores in the background without Lionel Richie talking about singing to Marvin. Alright, Marvin was a friend of mine too, you know? Alright, he's gonna sing a song to keep y'all going, but we gotta look for the infant issue. So, what I am going to do is I'm going to go back to those folders because it's in a I Am Some Dude folder, and it's the infant estate information that we need to be. I know, the infant. Okay, you all have heard about it, so let's go and talk about it. You see where it says infant adverse possession? Please go to IamSomeDude.com and you can pull up these documents without having to search the entire internet. Now, let me let you know, even if you were to search the entire internet, you wouldn't find it. Why? Because the book that it comes from, sorry, my mouse is holding up on me. I need to reduce it. Right about, no, that's a little too small. I want you guys to be able to see it up close and personal. Now, this is from a book called, as you can see right here, Corpus Juris Secundum. Now, some of you may not have heard of this book. It's either Corpus Juris Secundum or its acronym CJS. Now, this is page 3. I want to go to page 1. Okay, so you'll see what's going on here. Now, did you know that a minor and an infant can own property? Yes, they can actually buy and purchase property and open up accounts in which to put their money and determine where they want their monies to be put. I know, Corpus Juris Secundum. See right there? These are the precedent-setting case laws that deals with the foundation of all of the rulings in these so-called courts. Now, we have a lot to talk to you about this year, so I want all of you to be prepared. A lot of the time while I was in that facility, I was doing research and also helping people in the facility and got to see at least 5 people go home. Two of them, no, oh, yeah, 2 of them went on bail. The other one, the bail is over. His case is over. Trying to hold that person in jail as a so-called material witness and not giving him bail for 9 months. So we had to write to the court and let them know that the individual had a due process right to a speedy trial. And next thing you know, they were speeding him out of that so-called facility. All right, now look, we're going to read this right here, just this section so you guys can catch up to where we are. The petition must state all the necessary jurisdictional requisites. In general, it must state that the minor resides in the county where the proceedings are being brought, and that the minor is capable of managing his or her own affairs. Now, what petition is it talking about? Well, it's talking about the petition for the removal of minors' disabilities or disabilities of the infant. As in other suits, it's a civil proceeding. Now, notice by publication or the filing of the petition is sometimes required, but the failure to do so is generally not a jurisdictional defect. Okay, now let's go on and understand what's going on here. See, what they don't tell you when you are going through this so-called life dealing with the maze of stupidity, commercialism, is that you're an infant until you reach or obtain the age of maturity, but the word here that they use, these judges, is the age of majority. Mariah, let them know about saying bye-bye. This is Mariah Carey with her song, Bye Bye. I actually like it a lot. Now let's go on to this paragraph. There generally must be a hearing on the petition for the removal of minors' disabilities, at which such petition may be contested, but they can't contest the certificate. Why? Because we're going to tell you how to process this certificate, this petition, before the court. Now, the grant or refusal of the application is within the discretion of the court or judge. Now, this is a different judge. See, this is a judge in equity. And the judge does not get to determine whether or not you are no longer a minor or an infant. You are the one who determines that. Okay? Now, when they say it's at the discretion of the judge, you'll see why that would be the case. But let's go on just a little bit further. The removal of disabilities of infancy by judicial emancipation is effected by a decree, an order, or judgment, which must comply with the statutes and practice of the jurisdiction in which the application originated. Okay? It didn't say originated there, but that's what it means. Such a decree or order or judgment substantially follows the language of application for statutory authority. It is sufficient. The facts given jurisdiction to the court must plainly appear in the judgment of the court. Now, it talks about statutory this and statutory that. We're not concerned about statutory right now. What we are concerned, remember I told you an infant can acquire property? An infant may acquire property rights, and he or she cannot be deprived thereof except as provided by law. So, all of those people who've had their homes taken from you, well, they did it because you were an infant. Now, let's look at this right here. Statute of limitations either do not begin to run against the infant until the attaining of majority, or where infancy does not toll the statutes. The infant is allowed a statutory period after attaining majority to contest an adverse possession which commenced during his infancy. Now, wait a minute. When does the statute of limitation toll? Well, ladies and gentlemen, there is a basic foundational maxim when it comes to statutes of limitation. The statute of limitation does not commence to run until the last overt act has been accomplished. Now, generally, right here, an infant may acquire property rights, but he or she is not regarded as capable of managing his or her property. Hence, the law does not entrust him or her with the custody or control of his or her own estate. An infant may not be deprived of his or her own property rights except in the modes provided by law. Also, an infant has no legal capacity to irrevocably to abandon his or her property rights. You see, you don't have a legal capacity to irrevocably abandon your so-called property rights. Everybody who loses their home, it is through abandonment. Ladies and gentlemen, the banks claim that you abandon the property. Now, these are the case laws for which this is taken from. Now, what we're going to do is we're going to show you how to use this information from Corpus Juris Secundum to take back what's yours. Okay? You got that? All right. Now, it talks about the suspension of the statute of limitation against infant rests on express statutory provisions and not on common law. An infant may acquire title by adverse possession in the same manner as an adult. Now, see, it lets you know that an adult is a person who reaches the age of majority. Okay? Now, I promise you this, all of this right here, we're going to cover because this is very, very important. Now, you guys hear that in the background, right? I mean, I have this Windows system set up to where it sounds like it's a 7-speaker surround sound system. When the music first came on, I thought it was the people here playing music across the way. It sounds that perfect with these headphones. So let's get back to this. Yes, I'm back. Anyway, yes, I know. Perfect title. I'm back. Hey, ladies and gentlemen, I'm back. And I don't mind telling you that there are 3 videos that I have done. I'm going to put up the other 2. They don't have music, so I might just redo them. It'll be a lot easier redoing them than to be adding music to them later. Okay? Right here, we're going. Where an infant is in absolute and lawful possession of money as his or her own property, he or she has the right to deposit it in any place for safekeeping, as in a bank. An infant has the right to deposit his money in any place for safekeeping, as in a bank? No, look, he or she has the right to reclaim it at any time, and the person or institution so paying it to him or her assumes no risk in doing so. That's right, if we gave him the money and he went out there and squandered it, that's not our responsibility, even though he was an infant or a minor. Ladies and gentlemen, let's continue. In a matter of depositing or withdrawing funds, an infant is in the same category with an adult, subject to the same obligations, equities, and defenses. Interesting, ain't it? An infant? You guys need to understand. This is what's going on. You're construed as an infant. Now, to prove it to you, let's look at some of the cases. This is United States versus Moore. Well, United States case, Moore versus Harrell, and it's a court of appeals for the 10th Circuit. Circuit Court of Appeals, CCA, for the 10th Circuit. Okay, this is a Louisiana case. This is a Minnesota case. This is a United States, Oklahoma, Indiana, Illinois, DC, New Jersey, Minnesota, Indiana, Kentucky. Do you understand? This is going on all the time. Let me prove it to you. 1971, 1952, 1943, 1985, 1920, 1940, 1940, 1935, 1920. Ladies, gentlemen and ladies, 1859, 1813. Do you not understand this is what they've been doing the whole time? They've been construing, saying that you guys are infants. So when you're before the stupid judge, the one whom you presume is a judge, presume, it doesn't matter. They are saying that you are an intermeddler with the estate of the infant. And let's find out what happens to intermeddlers. Anyone who intermeddles with the property of an infant without authority is liable to the court therefore. Thus, an intermeddler may be liable for rents and profits or for any injury to the infant's estate, although he or she may not be liable for such injury if his or her administration is beneficial and he or she accounts fairly. Ladies and gentlemen, you have the right to administer your own estate and not be held liable for any of the intermeddling that they claim, but you have to so state it. Such a person may be treated by the infant as his or her guardian or bailee, although the relationship cannot be set up for his or her own benefit against the infant owner. Do you understand that? They're saying that the infant is not the one doing this, but if you're doing it to assist another, then you cannot be held accountable for it. You are to be treated by the infant as such and such guardian or bailee, although the relationship cannot be set up for your own personal benefit. Let's go ahead and deal with jurisdiction. We can read this section here, but let's read it here, where it talks about courts of equity. Courts of equity have general and inherent jurisdiction over the property of infants. Primary jurisdiction over estate of infants may, under constitutional or statutory provisions, be vested in the probate county or district courts or other specified courts. So the courts have inherent jurisdiction over the property of infants. Every single court case is an infant estate matter. That's why the birth certificate is attached. Now, some of you have filed bankruptcy. Many of you have filed bankruptcy based on the certain economic conditions of America at this time. What you didn't know is that you're filing bankruptcy against yourself, against your mishandling of the estate. That's why it's you versus the estate. Don't worry about it. We're going to show you how to switch the tables according to what they say in their laws. Jurisdiction can be exercised only when the court has acquired jurisdiction as to the particular infant and subject matter. The commencement of a proceeding affecting the infant's property vests the court with jurisdiction over his or her estate. Now, pursuant to which the court acts as in loco parentis and as a guardian. You're a ward of the state. The infant becomes its ward. Now, ladies and gentlemen, I want to promise you, I did not read ahead just then. I just understood it. You see, I haven't looked at these pages for over 9 months. And when I looked over them, I didn't go over this section. But it made sense to me when I just was reading, and actually I said something before I even looked at it. Now, the screen I have, this computer that I'm using has touchscreen, okay? So you may see things like that going on. It's not a bad Hewlett Packard piece of junk. Sorry, I've been through 6 computers trying to get this right, and then I had to find a screen recorder so I can get these videos out to you. So I'm going to try to get this one done and get this one up today. This being, as you can see, the 22nd of March. Now, many of you have heard that this man was no longer inside of a facility. Well, that's true and not true, but I'll explain everything in due course. But right now, we need to talk about this because this is the thing that's causing problems. We got one more document that we're going to talk about. Mariah, thanks for explaining Love Takes Time. So this is going to take time for you guys to get it, okay? Now, generally, Luther, hey, ladies and gentlemen, this is Luther, okay? This is Luther, and he's going to tell y'all about dancing with his father again. All right, that's Luther. Generally, an infant may acquire property rights, but he or she is not regarded as capable of managing his or her own property. Hence, the law does not entrust him or her with the custody and control of his or her estate. Now, wait. You mean you don't get to control your own estate? No, but we're going to show you how to control your own estate. An infant may not be deprived of his or her own property except by modes as provided by law. Now, we went over this a moment ago, so let's go to... I'm supposed to be touchscreening it, y'all, and it ain't letting me. All right, let's go to page number 2, and we're going to come back to jurisdiction to show you how you get control of your stuff. It is the duty of the court to safeguard the infant's property interests with great care. So they're saying you're an intermeddler because you're mishandling the account, the estate, you're causing damage. And so they have inherent jurisdiction and power to prevent intermeddling. Anyone who intermeddles with the property of an infant without authority is liable to account therefore for your actions. So they're able to do whatever is necessary to prevent you from damaging the estate. I know you're going to have to go over this video at least 3 times, so I'm going to try to keep it short. But the idea is you're going to have to go over it at least 3 times, okay? It's just the way it is. All right. In the discharge of its duty, the court is not bound by the pleadings of counsel and may act on its own motion. After the jurisdiction of the court has attached, the court has broad, comprehensive, now pay attention, after jurisdiction of the court has attached, the court has broad, comprehensive jurisdiction and plenary power over the estate of the infant. In other words, hey, they can do whatever they want. Isn't that what they've been doing? But no, they've been doing much more, and we're going to show you because there's a document that we're putting together that we're going to show you exactly what's going on in the court. Now, hold on. It may be adjudicated that the rights and equities of the infant in property. You see, it can take away your rights or add to the rights, and it may cause to be done whatever may be necessary to preserve and protect the infant estate. They can do whatever they want. We're going to show you why that's true. However, the exercise of such power must be tempered with reasonable limitation. Therefore, the court cannot act in violation of constitutional or statutory limitation on its own powers, or permit the impounding of the infant's funds, or the creation of a trust like they do in the courts. They create a trust to deprive the infant of the rights to absolute enjoyment of the funds at majority. See, the infant reaches majority. Now this says 18. Let's go to 18 and see which court actually made that determination. That's 16, that's 17, that's 18, that's New York State, and what year? 1927. Uh-oh. I didn't ask for this. Bye-bye. See how it just pops up? I didn't ask for it to pop up. Alright, let's go to the next part, people. It says an infant is not competent to waive the statutory requirements enacted for his or her benefit and protection with respects to the manner in which the jurisdiction of the court may be exercised. See, it says you don't get to challenge the court's jurisdiction, nor can you waive the statutory requirements that are there for your protection and for your benefit. Interesting, ain't it? Jurisdiction of the court over a state of infants, jurisdictional judicial allowance for support, maintenance, and education. Now, ladies and gentlemen, we told you you all need your education, so let's tell you how you can get your education. Even if you still an infant and you don't know how to uninfant yourself. Let's pay attention now, because Mariah says a hero is coming along. Here I am. Anybody call me? Hey. Oh, you weren't talking to me. Okay. My bad. Where infants who have an interest in certain property are without other means of support and education, the court may order so much of such property as may be necessary for that purpose to be applied to their maintenance. And see, you get to apply for maintenance and education and support, while the allowance should ordinarily be made out of the income. If the income is insufficient, a reasonable allowance may be out of the principal. Amazing, ain't it? So you get to be paid to educate yourself and support yourself from the infant estate. So again, it's called Infant Adverse Possession PDF at IamSomeDude.com. Just go there. It's a wealth of information. And yes, I Am Some Dude is getting a plug from this man, because this information, when I saw it, I had to get rid of all of that junk I thought I knew. Ladies and gentlemen, it was a lot of junk, and I don't hold on to it no more. Okay? Thank you, Mariah, for saying we finally see the truth. See, the hero lies in me. Got her yelling now. Anyway, sorry about that, ladies and gentlemen. I'm in a very good mood. I've been looking for this copy all over the net for the last month. And one of the commissioners went and just typed in something in his computer this morning during a conversation, and he pulled it up. So let's just say thank you. Finally got it. See, she said I'll find a way. Alright, the allowance is subject to the future control of the court and may be altered with varying circumstances of the estate. The court may properly order reimbursement from the infant estate to one who, after he or she has in good faith assumed custody of the infant, expended his or her own funds for legal services in proceedings involving the custody. Come on. I'm looking to see the truth of the infant. Ladies and gentlemen, that's what the attorney's fees are. That's what the court fees are. That's what all the fees are, because they say they are looking after the interests of the infant. Capacity and validity in general. Generally, an infant has the capacity to acquire and own property. Didn't I say that already? This is where I got it from. Thus, an infant may receive title to property and acceptance of a deed in his or her behalf, and may be presumed. Similarly, an infant has the capacity to alienate and transmit title to property. While such transactions may be voidable, they are not absolutely void. Now, property held in trust. Oh, hey, this is Low Key, and Low Key is going to tell y'all about how he believes. I would let this song play, but you guys have heard it already. Those of you who listen to the video, all right. An infant may take hold, excuse me, take and hold property in trust, although he or she is subject to the same disabilities in administering the trust as in dealing with his or her own property. And the infant, now it says that the infant is subject to the same disabilities in administering the trust as in dealing with his or her own property. See number one. Now let's go see number one so that you guys can know where to go do the research that says that you have the right to administer your own property. Number one is actually kind of long. Look at that. United States is Oyama versus California. It's a Supreme Court case, 1948. Then we have Davis Committee versus Loney, and that is 1942, Kentucky case. Then we have Ramada Inns versus this person and his last name, 1982. Okay, we have several cases that speak of this, and then someone sent me denial of infancy. So, you must deny infancy, and it's best that you do it either in a declaration or an affidavit. People, you don't want to be executors anymore. You don't want to be executrix or any of that junk, because an executor, according to the rules of federal district court, is a trustee. Yeah, I know. But anyway, we're going to talk about that later too. So get rid of the executor. The declaration of executorship was not. Uh oh. Did you hear that? It's a lot of work being done on this computer. So look, let me show you. I got this going on. That's at 458.65 kilobytes. Okay. Let me just tell you, that's pulling. And then I got Windows pulling, downloading files. Let's see if they downloaded. This ain't gonna run. This has been messing up on me. Watch. Let's see. Because I don't believe. There we go. See, it's been messing up. So I'll have to download it later. Audacity. This is what's been happening, ladies and gentlemen, is people like me have been downloading video recording software. The unique thing about video recording software is if you don't have your audio codecs updated, then you're not going to be able to play songs like Low Key and Mariah and Luther and the Commodores in the background and have people hear it. Okay? So you need to update your audio codecs pack. There are several of them out there, so go download, okay? Plus, you need to update your audio codecs packs anyway so that you can play just about any video or any audio in just about every format, okay? All right, let's get back to an infant may take hold of property. An infant's acceptance of a trust may be confirmed or disclaimed upon his or her coming of age. See, you don't have to accept the trust. And if you disclaim the trust, an infant will be bound to the terms of a conveyance of property which he or she is to hold in trust, at least where he or she assents to such conveyance after attaining his or her majority. The word is majority, people, not maturity. Majority. This is Ray Charles. He's going to talk about every time he sings this song. Okay? It's about Georgia on his mind. That's my boy. All right. Since infancy is a personal privilege, well, people, I don't want infancy. I don't want a privilege of being an infant. I want the privilege, honor, and right to be an adult, to be a man standing on my own 2 feet, supporting my own 2 self. Comprehension? I knew you would. Now, where an infant acting as trustee for another takes legal title to property and at the direction and or for the benefit of the beneficial owner makes a conveyance of the property so held he or she cannot afterwards avoid the validity of the conveyance by disaffirming the same on a plea of infancy. I was an infant at the time. I cannot be held responsible for what I did. Well, the court's saying you can't do that. You know why? Because some people have tried. Infant beneficiaries cannot consent to termination of a trust for their benefit. It says infant beneficiaries cannot consent to the termination of a trust for their benefit. So don't do it as an infant. Do it as one who has attained the age of majority. I know y'all see what I'm talking about. They're playing word games here. An infant cannot consent to terminating a trust because he's incompetent, but an adult who has attained the age of majority can. And that's what the rest of the infant section says. How do I know that? Because I read it, ladies and gentlemen. And that's why I'm showing that to you, but I got one Mo's document I'm going to show to you. Now, this one, I think we're going to show you the gain. No, we're going to show you the case against they have a bankruptcy case involving my brother, and it's in California. I asked the idiot to leave me alone. The idiot, the attorney, who is going and trying to take my brother's property that he built from the ground up, that was when it just before 2010 was worth $1.4 million. Yeah, that's why they want it. Ladies and gentlemen, what I'm going to do is I'm going to show you, I'm just pulling this up because this was what I wrote to the guys who are incarcerated, not this. I'm gonna fix this up. You see, I needed that to be able to transfer the sayings. So by doing this, I can do that now. And then I can redo the wording. Okay? I can take care of all of that stuff that comes out of place because technically I don't need that. I need this section down here, the case law section. Okay? And for the removal of disabilities of infancy, that's the type of stuff I need. And I have the voice recognition that I'm going to take care of all of this with. Oh, that's right, this is Word. Shh. People, I was opening up a Word document so I can get to the documents that I had already on the computer. Bankruptcy. There we go. Come on. Hey, Luther. Luther! Anyway, sorry. There was the song by Ludacris where somebody kept saying, Luda! Alright, just so you know. Now, this is what I need to show you so you can see what's going on in the court. Okay, it is interesting. Now, first of all, what I want you all to know is everything I do as a private citizen of the United States, an interested party. See, I come in as a private citizen. Why? Well, because I'm a private citizen with rights, privileges, and most important, immunities. You, on the other hand, are not whom you claim to be and are... Oh, excuse me. This is voice recognition. Excuse me. Or legally represent. See, the reason why that's there, see, I can't stand this touchpad, but I like being able to touch the screen and get to where I need to get to. The United States government is a foreign corporation with respects to the 50 states, and then we look at Corpus Juris Secundum, section subsection 1785 of volume 20. Yes, that's right, over 20 volumes. The United States government is a foreign corporation with respects to the state. Now, the district, United States, according to Corpus Juris Secundum, subsection 2, is not a place but a body public, a body corporate. See, when the United States enters into commercial business, look at that, that's the highlight section. When the United States enters into commercial business, it abandons its sovereign capacity and is to be treated like any other corporation. These are the laws from Corpus Juris Secundum. You can find this section all over the internet. Just type in, when the United States enters into commercial business, it abandons sovereign capacity and is to be treated like any other corporation. You can also find it at IamSomeDude.com. Okay? Now let's go on a little bit further to see what else is going on. See, according to Corpus Juris Secundum, section 1785, federal corporations that are created under constitutional authority under the laws of the United States of America are not foreign corporations within the states of the Union. However, where Congress, that's where we're going. I shouldn't have done that. That's me touching the screen, and apparently it's expecting me to correct something. So y'all gonna learn this program with me, this computer, because I'm learning it. All right. Says when Congress creates a corporation merely by virtue of its authority to legislate for a particular territory and not by a general act, that corporation is a foreign one in any state or territory other than that in which it was created. That's just a jurisdictional issue. The corporation has no authority anywhere outside the place where it was created. Now, 1786, because that was 1785, a corporation created by or under an act of a territorial legislature is not a federal corporation, but a corporation of the territory, and it has the status of a foreign corporation in every other state or territory. Ladies and gentlemen, this is just saying that Congress and them can create a corporation, but the corporations are not 100% territorially jurisdictional everywhere. We're going to talk about that in a minute. Now, the agencies and the courts are operating under what is known as the Debt Collection Procedures Act. Now, many of you probably have never heard of the Debt Collection Procedures Act, but you have heard, well, the United States means a federal corporation. Well, that's part of the Debt Collection Procedures Act. It's actually the Federal Debt Collection Procedures Act. Now, you're going to see why this is so important in a minute. Now, the Federal Debt Collection Procedures Act can be found in Title 28. Tell them, Luther. Yeah. See, this is my song, y'all. I've always loved this song. Looked for it for years because I didn't know it was called Superstar. Made a song about me. Alright, sorry. Title 28, United States Code Service, sections 3001 to 3319. They created that to go in conjunction with the 14th Amendment of the United States Constitution. Wait, what you mean the 14th Amendment? But I thought you said that the Constitution was suspended during times of war, right? Well, that's correct. The Constitution is suspended during the time of war. However, the 14th Amendment does not need the time of war in order to be acted upon. What I will do is I'll break it down like this so that you can understand a little bit more clear. Section 1 of the 14th Amendment says, in part, a person born or naturalized in the United States are citizens of the United States and that of the state wherein they reside. Dual citizenry. That's what I want. No state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, or deny any person within their jurisdiction equal protection of law. You all have heard the same thing I heard. You don't want to be a 14th Amendment citizen. That takes away your rights. It makes you a second-class citizen, makes you a citizen of the corporation. Ladies and gentlemen, that is not true. Before the United States entered the so-called 28 Code of United States Code Service, okay, the Title 28, before they even invented that title, the 14th Amendment existed. Did it make people a second class citizen? Well, let's see for a second here because we keep hearing that. So let's see. Second class citizen. All persons born and naturalized in the United States are citizens of the United States or the state wherein they reside. Dual citizenry. Okay, the person has dual citizenry. That's what it says, right? And no state, including the United States, can make or enforce a law that abridges the privileges and immunities of citizens of the United States. Now, what if you are immune from? What are your immunities? We're going to show you in a minute. Now, you have to have, no matter what system of laws there is in this world, you have to have due process and equal protection of law. The United States cannot ignore that. Now, let's go up. I like the touchscreen, guys. Now, this is the young lady, Miss Jennifer Hudson, and a young man named Nayo, and they're singing Can't Stop the Rain. Love this song. There we go. All right, Section 4 of the 14th Amendment says, well, I want to bold this. Yeah, I'm going to bold all of it. Okay, and then what I'm going to do, the highlighted sections, like this right here, we're going to do that way. And we're going to do the same thing here. Okay, and then we are going to do one more thing. Come on down, mouse. Mouse is temperamental, y'all. It's too many cats out there. Okay, we're going to do public debt. Yeah, we're going to do the whole section. Public debt of the United States. And this is including debts incurred for the payment of pensions and bounty services and the suppression of insurrection and rebellion. Now, we're going to do that there. Okay. Now, notice this. Neither the United States nor any state shall assume to pay any debt or obligation occurred in the suppression of rebellion and insurrection against the United States. We're going to do this one, and I think we're going to do it there. Okay? Now, let's break this down, this 14th Amendment. Let me go over here and save this because I kind of like what's happening here. Ladies and gentlemen, the 14th Amendment, Section 4 says this. The validity of the public debt of the United States, including debts incurred for payment of pensions and bounties for services in suppressing insurrection and rebellion, shall not be questioned. Everybody brought before any court or accused of damaging either the state in which he or she resides or the United States. Now remember, the states are part of the United States. So when you damage a state, you're damaging the United States, which means you can't question, shall not be questioned. Let's make that red because some people are not going to get it. We're going to do that first, and then we're going to highlight it a little differently. I need something that's going to make it stand out. That's not going to make it stand out. That's going to make it stand out. Shall not be questioned. Matter of fact, I like the size of that, but we're going to do 10, and then we're going to go and get some size on the brother. Okay. Shall not be questioned. So all of you going into the court questioning their jurisdiction, questioning the judge's oath, questioning this, questioning that, saying, I didn't do this, I didn't do that. Please stop. Stop, because they've already told you they cannot be questioned. It says stop questioning them. Now, what you need to be understanding of what's going on. So I pulled it up. Let me see if I can read it. The letter I said I wrote to the guys in jail. Okay. And they speak Spanish, so I use Google Translate to send this to them. I just wanted to let each of you know that I have not forgotten about you and that I, as of this moment, am trying to put together an English Spanish translation software. And this is supposed to be so as to be able to, that's voice recognition, so as to be able to speak to all of you. And as such, should have, let's get rid of the as such, and should have it done within a week. Well, that was 2 weeks ago, but I sent it to them within a week. Now, to keep everything, the key to everything is the following. Pay attention. When a police reads someone their Miranda warning, they say something similar to the following. Now, please understand, it's a warning. Danger, danger, Will Robinson, danger, don't go down that street. That's where Kruger is, and you can't go down that street because Jason's down there. No, you gotta stay right here and wait for the Reaper. Ladies and gentlemen, uh-oh, warning, they found a lot of threats. Uh-oh. I'll just have to take care of those threats. I was doing a registry scan. It doesn't like the fact that I download keygens, but ESET is an alright virus scanner. Oh, this is Ray Charles, ladies and gentlemen. He's singing a song that has been redone so many times, done by so many different people. Well, Ray Charles does this song better than just about anyone. Okay? I know Donny Hathaway, who is it? Whitney Houston. So many people have done this song, including, I can't think of the young lady's name, Regina Bell. Hers was the first one of this version that I heard that I really liked, but Ray, nobody does it better than Ray. Sorry. Alright, ladies and gentlemen, the police warn you, and you don't heed the warning. Okay, let's make sure we understand what's going on here. Okay, come. Copy. I didn't put it all the places where it should be, so I'm gonna put you where you should be. Okay. You'll understand. Many of you already understand. You're already anticipating what I'm gonna say, but I want you to shut up. Shut it up, like Martin used to say to Gina. I want you all to be quiet, to remain silent while the rest of the people catch up to us, okay? The police say you have the right to remain silent. Do you understand? Anything you say may be used against you in court. Do you understand? Now, other jurisdictions, you've heard television where they say anything you say can and will be used against you in a court of law. You have the right to the presence of an attorney before and during any questioning. Do you understand? If you cannot afford an attorney, one will be appointed for you free of charge before any questioning if you want. Do you understand? Do you wish to waive? Sorry, hit the headphone because I'm pointing and gesturing. Do you wish to waive these rights? And what happens? No, I don't know. Well, let's take a look. Most of you have heard it said on television You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to speak to an attorney and to have an attorney present during any questioning. If you cannot afford an attorney, one will be provided to you at no charge. If you should give up the right to remain silent, anything you say can and will be used against you in a court of law. Do you understand the rights I just read to you? What am I trying to say? Let's find out what I was trying to say to them. What I'm trying to say to all of you is that you are not you. When used by the court or the court officials, officers, agents, you might as well take care of that now. Yeah, apparently you guys are hearing Ray Charles. He's doing that before a college audience.
55,000 students out there. Appreciate
55,000 people that man did that song in front of. And he says, all right. Anyway, you is referring to a group, not an individual. You
how we're going, okay? We'll be right
gotta highlight it because it's a separate you. It's a legal term. Generally refers to enemies of the United States and of the governments, war rebel, insurrectionists. That information is taken from the 14th Amendment of the United States Constitution. Now, we're going to come back to this because it's important that we go over this again. The validity of the public debt of the United States shall not be questioned. And if they want to pay their pensions and bounties for services or fees for services in suppression, insurrection, and rebellion, you can't question it. You cannot question it. There's only one way that such can be questioned. Now, before we discuss that, let me let you know what the courts are doing. Every case is a debt against the United States. So you are a loser from the very beginning. And those Miranda warning so-called rights, those are not rights. Those are contractional statements. A verbal contract is just as binding as a written contract. Ladies and gentlemen, the officer of the court, the police officer, is entering into a contract with you. Now, I'm going to show you how to get rid of that stupid contract. Okay? But we're going to talk about that in a minute. See, I'm working on my brother's bankruptcy to take care of a couple of things because, like I said, the attorney's being kind of stupid that's trying to take his house. Now, to prove to you that the courts are working and operating as a debt collection agency, they're operating under Title 28 of the United States Code, Section 3000 to 3319, or 3319. Go ahead and take a look at it, and you'll see. Oh, by the way, during a time of war, look at Amendment number 3, number 5, and number 14. Those are the only amendments available to you in those stupid courts. Why? Well, because you're an insurrectionist and a rebellionist. But you can't avail yourself of those amendments. Why? Because insurrectionists and rebellionists have no rights. That's why you can't question anything. But I told you there is one way for you to do so. See, what you do is you tell them, I do not waive a single right, and I withdraw any and all consensual agreement, quasi-contractual or otherwise. And as I shall not, that and ain't supposed to be there. Sometimes when you say comma, it adds an and. I shall not participate nor be a party to insurrection or rebellion against the United States, nor of her superior interests or that of her citizenry. So you disavow any knowledge of being an insurrectionist or rebellionist. No, you say the United States is a sovereign nation and I'm fully supportive of the United States' sovereign capacity. and I shall not be made a party to any insurrection or rebellion or conspiracy against her interests or the interests associated thereto. I disavow any claim or knowledge of having willingly participated in any insurrection or rebellion against the United States of America. I do not and shall never join in any conspiracy by or of any private commercial business entering engaging rogue corporations. We're going to put corporation. No, I said by or of any private commercial business engaging entering rogue corporations. I love the United States, the sovereign nation, and I am honored to serve in the interest thereof, and I shall not be a party. I said not be a party to, nor consent to any activity that brings harm, damage against the sovereign nation of the United States of America. So help me. See, if you don't disavow being part of a conspiracy, being a part of you, being part of an insurrectionist group or a rebellionist group, then you have no rights. Now, you just stated in that statement that the United States corporations are rogue agencies. See, I know for a fact that the government cannot engage in commercial business, as that would be tantamount or equate to gambling with the public's credit, interest, and or monies. Ladies and gentlemen, pay attention. They trade on the stock market. They can't do that. Do you understand? They cannot engage in commercial business while holding on to sovereign capacity. Why? Because the stock market is a gamble. Commercial business is a gamble. Why? Because it fluctuates. There are no guarantees that if it cost $200 yesterday, it's going to be worth $200 tomorrow or $400 tomorrow or $5 billion the next day. So it's a gamble. Okay? A gamble. So they can't gamble with the public's monies. Now you say, this is my decree, and I shall not be compelled to participate and or be a witness against the interests of the sovereignty of the United States, her citizenry, or my own interests. You have been notified as required via due process, and the record has been properly documented. I shall not change my mind or course or any verbal or written engagement. What says that any verbal or written engagement shall be in and remain in the private for the private record, as I do not and shall not ever conduct personal business publicly. You let them know that you're doing this in your private capacity, your private citizenry capacity. We're going to talk about set off later, but what I want to do, give me a second. Oh no, this is a lot of stuff that UCC stuff. I don't want that. Okay, this is the wrong document, so I've done all I can with that document. This is Mariah singing live. She wants to know what love is. I guess something happened with her and Nikki, because I hear they ain't together no more. Man, who could have seen that coming? Like I said, Espanol. Alright, so dagnabbit, I gotta look for another document. Give me 1 second, folks, because I did something unique. And while I look for this document, I'm gonna tell you what was so unique about it. This is the Game Stopper. Can't do that either. Do I have 2 Game Stoppers? Yes, I do. Okay, one's in documents. Oh, goodness. The document I'm looking for is my document. Dagnabbit. Alright, we say open. No, I don't want to recover no unsaved documents. Yeah, gotta go here. Gotta go here. I'm looking for a document that I did for me. Oh, that's in documents. Sorry, I was in the wrong folder. I know exactly where I'm going. Or did I move them? Yes, I moved them. I moved them to the folder I was just in. Okay, let's see if I can find it. Don't want the Federal Reserve Bank. Those are old documents. That's old. That's old. All of that's old. I need something new. Infant. Oh, you know what? I I'm going to open this only for the moment. Ladies and gentlemen, this is muscular dystrophy, okay? And it's what a person goes through with muscular dystrophy. Since this occurred, the symptoms have actually gotten worse, and the fatigue has gotten worse. Now, as much as I tell people to keep their crappy little ideas about treatment and health benefits to themselves, they keep trying to educate me. Stay up out of my life, okay? I will take care of my own health. My God that I serve, who has been with me every step of the way with this, will take care of me. I understand that some of you worry about me. I understand that some of you care. I understand that some of you love me. But please, I am tired of everybody and their suggestions as to my health. Leave me be, okay? I am fine. But I'm pulling this up to let you know what I go through. Now, this such as hips and pelvis and legs, I can't tell you how many times my legs have given out on me and I didn't know why. Or the fact that I've been standing up during this whole video and how much my back is hurting me. Or trouble leaning or learning to sit independently and walk. No, I need to grab hold of the chair before I sit down. And this unsteady walking, man, you should see me. The next one is the important part. Walking on toes or balls of feet. I thought it was because my feet were flat that I crunch my toes up and I walk on my big toe, especially with my right foot. I'm always putting holes in shoes. I thought it was me. Or that I'm dizzy all the time. Don't fall too much, but man, I'm dizzy all the time. Or trouble climbing stairs. You know, people, you look big and strong. You've been eating your vitamins and your spinach. So, ladies and gentlemen, if you want to see what I'm going through, just go to the internet and look up muscular dystrophy, and you'll see what I go through on a daily basis. There is no cure, okay? There is none, and so you can't offer none. And I'm not looking for a cure. Okay, if I was, I'd be saying, do any of you guys know how to cure muscular dystrophy? Because Jerry Lewis sure didn't know what he was doing. You don't hear me doing any of that. So please stop. No more suggestions. Okay, some of you are going to suggest, and you're going to hate me. Okay. Oh, you guys thought that I would change. Sorry, Charlie. Starkus can't stand tuna anymore. So no, I'm not changing anytime soon. I've improved on a lot of things. I even have a little bit more tolerance for stupidity, but not a whole lot of tolerance. You know, I can't find the document. Oh, that's a shame. Okay, let's see if I can pull up. I'll I'll definitely have to pull up something online to show you what I've done because I just maybe it's here, maybe it ain't here. Somebody go, oh, there it go, and no, that ain't gonna work because I couldn't hear you. Okay, so I tell you what I do. I close that. I close that. Of course, I want to save that, and I close that, and we go to the outer net. Okay, we're gonna go to the outer net. Ladies and gentlemen, the outer limits. Maybe it's in here. Nope, that's not there. Okay, let's go here. I am a mountain. He's the world's greatest, they tell me, you guys. Alright, we're going to add another one. and we're gonna do something. I want to show you guys what I did, and then we're gonna end this, and then I'll take a little bit more time with the next video. No, we can't. Oh, we're gonna look up a word, okay? Now that's Wikipedia. I don't care about Wikipedia. Let's do void as defined in the dictionary. I want to do Merriam-Webster because they have a reputation. Okay, so let's see if we can. I'm the world's greatest. Let's see what type of an hour. Fallen skies, fallen skies, fallen skies. Un momento. Alright, ladies and gentlemen, as I said, I was going to look up the word void. What I've done is I've taken the word void and I put it at the end of my everything. This right here is what's happening where I am. They don't want me there. Okay? So it may take me a couple of days of getting this up, but don't worry. What I did at the end of my signature is I put the word void, VOID, at the end of my signature. I did it in cursive. Okay, you can handwrite it. You don't have to put it in the middle of the document. You don't have to write it across anything. You just put it with your signature. When you're signing for tickets, when you're signing for anything, you just put the word void at the end. It cancels the contract. You don't believe me? Go and look up what void means. Alright, ladies and gentlemen, we'll end this with R. Kelly telling you guys about him being the greatest. Alright, take care of yourselves, have a good evening, have a good night, and I will speak to all of you later. Goodbye.